Hello everyone. Today we will be talking about the no recourse to public funds, something most migrants are familiar with. Whilst the government continues with its hostile environment, the High Court, or the higher courts on the other hand, continue to find in favour of migrants. I am Kareesha Turner, your human rights barrister on Kareesha Law. Continue watching for more. The High Court has ruled that once a migrant is recognised as a refugee, they can backdate their child tax credit as long as such a claim is made within a month of them receiving their status. Whilst this is welcome news, most migrants would be aware that they're not to claim benefits. Their BRP that they receive or the letter of grant clearly says that they are to have no recourse to public funds and not to claim benefits. A person a migrant who claims public funds, despite such a condition, is committing a criminal offence, and there may well be future immigration consequences, as well as having their leave curtailed or future applications refused. What constitutes public funds? Here is a list of what counts as public funds for the purposes of the immigration rules at paragraph 6. This appears on your screen as I speak. This is a discretionary power, it is important to know. It does not have to be used by the Home Office. The general rule for those categories is that the no recourse to public funds condition will normally be imposed, but there is a discretion not so. Discretion will be exercised, for example, where the applicant is destitute or where there are particularly compelling reasons relating to the welfare of a child or a parent in receipt of low income. But the general rule or the policy is that those seeking to establish their family life in the United Kingdom must do so on the basis that prevents putting additional burden on taxpayers and promotes integration. However, the no recourse to public funds can be lifted in certain circumstances if a person can show they meet the requirements. Often, the Home Office will carry out her own assessment, or even if a local authority has carried out an assessment. The way the application is presented is important. The evidence that you put forward is important, even if you have already been seen by a local authority. Last year, the High Court found that the Home Office's policy on imposing the no recourse to public funds for people granted leave as parents of a British child was unlawful. So claiming from the public purse is not a neutral position. Very often I say this to my clients, this can be used against you, and I always advise caution here. But for those of you who believe they are destitute and want to have this condition lifted, contact me. I will assess your case and help you and advise you as to the way forward. For parents who have limited leave but have a no recourse to public funds attached to their conditions of leave, this is unlawful and can be challenged. Again, this is something I can help you. I encourage people to work where they can or fund themselves where they can. But if you require help with regards to the no recourse to public funds, contact me and I will be able to advise you and help you. You have my platform, or you can contact my clerk. I hope you've enjoyed today's video. Thank you for watching Kareesha Law.